Bet you can't guess which of these lawsuits actually won. A psychic sued a phone company for breaking her powers. A man sued himself, then asked the government to pay him. A burglar got trapped in someone's garage, ate their dog food, and filed for emotional distress. These cases were filed, argued, and heard by real judges. Some got dismissed. Some settled for millions. One exposed corporate negligence the media buried for decades. The legal system is equal parts justice and absolute chaos. And these 10 cases prove it. 10 real cases, ranked. The verdict on each one will change how you read a warning label.
Lawsuits exist for protection. Someone causes harm, someone seeks justice, the court decides. Simple. But sometimes, the courtroom becomes a stage for absolute creativity. Because technically, anyone can sue anyone. You could sue your neighbor for looking at you wrong. You probably won't win, but you can. Winning is a very different story. Let's start the countdown. Number 10. The psychic who sued because her powers failed. In the early 1990s, a psychic in New York sued a phone company. Her claim? Her psychic abilities stopped working, and she blamed the phone company for causing emotional distress. Yes, a psychic. Arguing in court that her supernatural abilities malfunctioned, she demanded over $100 million in damages. Now pause. If you can predict the future, shouldn't you have predicted this outcome? Shouldn't you have foreseen the dismissal, the judge's exact facial expression? The case was dismissed almost immediately, but it made headlines worldwide because the legal system had to officially consider the sentence, "My psychic powers stopped functioning." Would I file this lawsuit? No. My self-awareness would intervene first. But imagine being the judge that day. You spent 3 years in law school. You passed the bar. You built a career. And then one Tuesday morning, someone hands you this. Law school absolutely did not prepare you for that paragraph. If that felt unrealistic, the next case involves someone suing over spilled coffee. You've heard this one. Everyone has. But I guarantee you haven't heard it correctly. Number 9. The McDonald's hot coffee case. Here's the version most people know. A clumsy woman at McDonald's spills her own coffee on herself, then sues a billion-dollar company for her own mistake, gets millions, and somehow triggers a wave of "caution hot" labels on every cup in America, as if we needed to be told. Classic example of a frivolous lawsuit, right? Wrong. That's the myth. Here's what actually happened. In 1992, a 79-year-old woman named Stella Liebeck ordered coffee from a McDonald's drive-thru. She was not driving. She was a passenger. The car was parked. She held the cup between her knees to add cream and sugar. The lid came off. The coffee soaked straight through her clothing. Here's where the myth falls apart completely. The coffee was served at 180 to 190 degrees Fahrenheit. That temperature causes third-degree burns in seconds. And it did. She suffered burns across 6% of her body. Skin grafts were required. She was hospitalized for 8 days. She initially asked McDonald's for around $20,000 to cover her medical bills. McDonald's counteroffered $800. $800. For skin grafts and 8 days in hospital. Generous stuff. The case went to trial. And during that trial, evidence revealed that McDonald's had received over 700 prior burn complaints about their coffee. 700 people. They knew the temperature was dangerous. They kept it anyway. The jury awarded $2.7 million in punitive damages, roughly 2 days of McDonald's coffee revenue. The judge later reduced the total to around $480,000. This case became the symbol of frivolous lawsuits across America. But it wasn't frivolous. It was corporate negligence, dressed up in a very effective media narrative. Sometimes the weird headline is hiding something very serious underneath it. Number 8. The man who sued himself. In 1995, a prisoner in Virginia decided the legal system needed a new challenge. He sued himself. Yes, his claim was that by committing a crime, he had violated his own civil rights, so he requested damages. But here's the beautiful twist. He was in prison and had no money, so he asked the state to pay him on his behalf. Let's replay that. He committed a crime, blamed himself for it, and then asked the government to fund his own compensation. The court had to respond formally. The judge dismissed the case, but not before writing a full legal explanation for why a person cannot sue themselves for violating their own rights. That document exists somewhere in a courthouse. A judge used valuable court time to officially explain why you are not allowed to sue yourself, because apparently that needed clarification. Would I attempt this? No. My logic would short-circuit at, I am both plaintiff and defendant. But creativity? Genuinely unmatched. That man saw a system and said, what if I broke it from the inside? Respect. Not legally, but personally. Now we move from creative lawsuits to lawsuits about bruised expectations and one man's very specific disappointment with beer. Number 7. the man who sued Anheuser-Busch over beer ads. Here's what you'd expect this case to be. A man gets drunk, does something embarrassing, and blames the advertising. That would actually be more defensible than what he argued. In 1991, a man sued Anheuser-Busch because their beer commercials featured attractive women and glamorous lifestyles. His claim? Drinking the beer did not produce those results. He wanted $10,000 in damages, not for injury, not for illness, for the emotional wound of reality not matching the commercial. He essentially walked into a courthouse and filed paperwork that said, "The ad promised transformation, I got a beer." And look, emotionally, relatable. We've all watched a commercial and felt personally betrayed. But legally, the court dismissed it before he could finish the sentence. Because advertising exaggeration is not legally binding magic. If it were, every perfume company on earth would be in prison. The confidence it takes to not only have that thought, but to also write it down, sign it, and hand it to a judge, that's a special kind of self-belief. Legally valid? No. Inspirational? Honestly, a little bit. Now imagine suing someone for breaking into your house. Sounds completely normal until you find out who filed the lawsuit. Number 6, the burglar who sued the homeowner. Most people assume this story ends with an arrest. Break in, get caught, go to jail, story over. In California, a burglar broke into a home through the garage. The door shut behind him. He got trapped inside for several days. He survived by eating dog food and drinking soda from the fridge, which is already a punishment, honestly. After being rescued and arrested, he sued the homeowner for emotional distress. He claimed he suffered mental anguish while trapped. Let's just sit with that for a moment. He committed the crime, got stuck, I ate dog food, and then filed paperwork about his feelings. And here's the part that shocks everyone. The case resulted in a settlement. Yes, a settlement. Money changed hands. This wasn't a judge losing their mind. This was a liability law doing exactly what it's designed to do. Even criminals retain certain legal rights under specific circumstances. Would I sue after breaking into someone's house? Absolutely not. I would take the L quietly and move on with my life. But this case proved something important. The legal system is not about morality. It is about technical liability, and sometimes technicality wins, even when everyone involved knows it probably shouldn't. Quick pause before we get to the truly unbelievable ones. If you've made it this far, you already know this video is different. And the next 4 cases, they're worse, in the best possible way. Hit subscribe so you don't miss what comes next from this channel, and drop a comment below. Which case so far would you have ruled on differently? Okay, back to the lawsuits, because we still have pants, a haunted house, $13 million worth of wings, and an actual lawsuit filed against God. So far, we've had a psychic suing over lost powers, a coffee case that wasn't what anyone told you, a man suing himself and asking the government to fund the settlement, a beer disappointment lawsuit that somehow made it to a judge's desk, and a burglar filing emotional distress claims after eating dog food in someone's garage. And we're only halfway through. The second half is worse. Let's go. Number 5, the haunted house that was too scary. You see this headline and assume it's fake. A woman visits a haunted house, gets scared, sues for being scared. Surely this is satire. It is not satire. A woman sued Universal Studios after visiting their haunted attraction. Her claim? It was too frightening. She experienced emotional distress. Now let's trace the decision-making here. She chose to go to the haunted house. She chose to buy a ticket specifically for the purpose of being frightened. She stood in a line designed around the promise of fear. She walked through a door that said, "In every possible way, we are going to scare you." It scared her. She sued. The court dismissed it immediately. Reason: assumption of risk. If you purchase horror, horror is legally included in the transaction. No settlement, no payout, no wings, no emotional damages. Just a judge formally writing the sentence. Being scared at a haunted house is not negligence, which is now a sentence that exists in legal records. Somewhere there is a law professor using this case as an example, and that professor is doing their absolute best not to laugh while teaching it. Number 4, Red Bull doesn't give you wings. Here's the version of this story most people assume. Man drinks Red Bull, doesn't grow wings, sues as a joke, case gets thrown out, everyone moves on. A funny little story that went nowhere. That is not what happened. In 2014, a man named Benjamin Carruthers sued Red Bull. His argument was that the slogan, "Red Bull gives you wings," implied real, measurable performance benefits. Benefits the product didn't actually deliver. Now, obviously, no one was expecting literal wings to sprout from their shoulder blades. That's not the point. The lawsuit targeted the implied claims: energy, performance, focus that the marketing suggested. And here's where it stops being funny. Red Bull didn't fight it. They settled for $13 million. $13 million. Any consumer who had purchased Red Bull between 2002 and 2014 could claim either $10 cash or $15 worth of Red Bull products. No receipt required, no proof of purchase. Red Bull denied any wrongdoing, then handed over $13 million, as one does when one is fully innocent. This wasn't about wings, it was about the legal line between a catchy slogan and a misleading performance claim. And that slogan crossed it. Let the record show, the wings did not arrive, but the check did. If you think $13 million is expensive, wait until you hear how much a pair of pants cost one man. Not to buy, to lose in court. Number 3. The $54 million pants lawsuit. First instinct when you see that number, it's a typo. Surely it was $54,000. Surely the dry cleaner did something unforgivable. Surely the person filing was not a professional who worked inside the legal system. Wrong on all 3 counts. In 2005, a Washington, D.C. administrative law judge, a man who spent his career inside courtrooms, sued his dry cleaner for losing a pair of pants. He demanded $54 million. His legal reasoning was that the shop's "satisfaction guaranteed" sign constituted a binding promise, a promise that had been broken by the pants. The case went to a full trial. It lasted years. The small family-owned dry cleaning business spent over $100,000 defending themselves. They eventually had to close one of their locations because of the financial pressure. The judge lost the case. He received nothing. He later lost his judicial position when the city declined to reappoint him. So the final score? Dry cleaner. Financially devastated, one location closed. Judge. No money, no pants, no job. Pants. Still missing, probably unbothered. This wasn't a victory for anyone. It was what happens when someone with legal knowledge uses it as a weapon against people who can't afford to fight back. Nobody won. Everybody lost. And somewhere, a pair of trousers remains at large. Now imagine suing not a company, not a person, not even your dry cleaner, but God. Number 2. The man who sued God. First reaction? Fake. Second reaction after reading the full headline, performance art by someone with too much time. Third reaction when you actually look it up, it happened. It was filed. It was real. In 2008, Nebraska State Senator Ernie Chambers filed a formal lawsuit against God. Not metaphorically, an actual lawsuit. His listed claims included causing natural disasters, acts of terror, and widespread human suffering. He requested a permanent injunction against further divine interference. The court faced an immediate and unprecedented legal problem. How exactly do you serve legal papers to an omnipresent being? You need an address, a verified method of service, jurisdiction. The case was dismissed. Official reason? Failure to notify the defendant. No service of process, no case. Which means God technically won on a technicality, which is the most God thing that could possibly happen. Chambers later clarified his intent. He said it was symbolic, designed to prove that anyone can file a lawsuit in America, regardless of how absurd the claim. And he proved it. For a brief, beautiful moment in legal history, the official court docket read, "Plaintiff versus God." You absolutely cannot script that. The courts tried. Even they couldn't figure out how to serve the papers. And now, number 1. The lawsuit that proves even your own parents aren't safe. Not from an accident, not from negligence, from the simple, unavoidable act of creating you. Here's the version that sounds made up. A man decides his parents owe him money. Not for abuse, not for neglect, not for anything they did wrong. For the act of bringing him into existence. You'd assume this person had no legal knowledge, filed something ridiculous, got dismissed in 5 minutes. Everyone laughed. The end. Now here's reality. In 2019, Raphael Samuel of India announced plans to sue his parents for giving birth to him without his consent. His argument was rooted in antinatalism, a genuine philosophical position holding that it is morally wrong to bring people into the world because life involves suffering they never agreed to. He laid it out clearly. He didn't ask to exist. He didn't consent to the terms. He didn't sign anything. Therefore, his parents owed him compensation for a lifetime of obligations, struggles, and ultimately death, which he also didn't ask for. His mother, who is a lawyer, which makes this even better, responded publicly. She said she would have been perfectly happy not to have him if only he had asked her before he existed, which is the most devastating legal counterargument in recorded history. delivered by his own mother in a press statement. The case didn't formally proceed through court. No jurisdiction currently recognizes the right to sue for the act of being born, but it sparked a genuine global debate, and it remains the one lawsuit where the core question was never actually answered. Not dismissed because it was wrong, dismissed because no court was equipped to handle it. The question, was being born worth it, remains officially open, and somewhere, Raphael Samuel's mother is still waiting for an apology she probably knows isn't coming. Here's what all of these lawsuits have in common. Anyone can sue. Winning requires evidence, argument, and at least one judge who doesn't visibly sigh when reading the complaint. But filing just requires paper and a fee. Some of these cases exposed real corporate negligence hiding behind a media circus. Some exposed ego dressed up in legal language. Some cost companies millions. Some cost plaintiffs their careers, their livelihoods, their entire reputation. And in the pants case, their pants, their money, and their job, all at once. But underneath every single one of these cases is the same instinct. Someone felt wrong, and they wanted someone official to agree with them, even if that someone was a judge. Even if the transcript of that agreement reads, "Red Bull did not provide wings." That's the legal system. Equal parts justice, ego, creativity, and absolute chaos. And honestly, we wouldn't have it any other way. Now I need complete honesty. Which case actually surprised you the most? The real truth behind the McDonald's coffee story? Red Bull's $13 million payout over a slogan? The pants lawsuit that ended 3 careers and 1 dry cleaning location? Or the man who sued for simply being born and whose mother responded like an absolute legend? Drop the number in the comments. Subscribe or I'm filing a $54 million claim against your attention span. See you in the next one.